Okay, David, we're back up and running.
Okay,
Sorry about the technical issues.
okay, AB 992 added provisions to the Brown Act relating to social media. And provides that the provision in the Brown Act that prohibits a majority of members of a legislative body from using a series of communications directly or through intermediaries outside of an authorized meeting, discuss, deliberate, or take action on any item of business does not prevent a member of a legislative body from engaging in communicating on a social media platform to answer questions, provide information to the public, or solicit information from the public on a matter within the legislative body's subject matter jurisdiction. However, a majority of the legislative body cannot use the social media platform to discuss business among themselves. And discuss among themselves is broadly defined in the statute. And discuss among themselves includes making posts, commenting, and even using digital icons, emojis, likes, that kind of thing, to express reaction to communications made by other members of the legislative body. Also, the law, this is in slide 10, has this new stricter, this was effective in 2021, stricter prohibition. It prohibits a member of a legislative body from responding to any communication on a social media platform regarding a matter within the legislative body's subject matter jurisdiction that is made, posted, or shared by any other member of the legislative body. So this is a stricter standard because otherwise two board members can talk to each other and it's not a violation. In this kind of instance, two board members interacting in this manner would be a violation. It's kind of interesting because AB 992 is set to sunset, to expire January 1st, 2026. And I did a little Googling, I can't find any bills or anything pending that would extend it. Although that still could happen. I'm not quite sure what happens when this came into being, and of course, being new, created a lot of discussion. But it won't exist anymore after January 1st of next year, unless it's extended by the legislature.
David, just one moment.
Hey, baby. Hi, Mom. Hey,
What about,
Michelle, you need to mute yourself.
sorry. What about, doing like, you know, saying maybe either an emoji or commenting on a post not made by another member?
The only problem is if three members do that, you could have a.
Oh, I see. Okay, so if one member does or two would be okay, but yeah.
Yeah.
Wow,
So you have to be careful.
Yeah.
And then you have the stricter prohibition on
Yeah.
top of that.
okay, thank you.
The next slide pertains to emails. Again, something to be careful about. Emails can present a problem. You can't use them to develop a collective concurrence. There's an attorney general's opinion on emails potentially constituting a meeting, a violation of the Brown Act. One-way communications is okay, but staff often, when they do that, will have a caveat saying, don't click reply all. You don't want to get into that kind of trap, you will. Okay, moving on to slide 12.
David, may I add something?
Sure.
And members of the pros committee, I'll send an email, basically, pros committee members, send this to you, BCC, to avoid, and I'll have that disclaimer. I'll still say, please don't reply all, even though it's kind of silly because you can't reply all to it. But I'll do that BCC to eliminate that whoops factor.
Under the Brown Act, there are several types of meetings. You have regular meetings that occur on dates and are set by resolution, ordinance, or other formal action of the legislative body. And you have special meetings under Government Code Section 54956, which can be called by the presiding officer or a majority of the board. You'll notice that the agenda for this meeting reflects that the special meeting was called by the chairs of the various committees and by the president of the board. Can't be called by staff. It's actually not a Brown Act violation for three members of a legislative body to communicate about holding a special meeting, but they can't really communicate about the substance of that meeting other than perhaps the topic to be on the agenda, but not to discuss the merits of the item. But typically, they're not called that way. Typically, they're called by the president of the board, in the case of the board of directors, or the presiding officer of the legislative body. There's also emergency meetings. It has to be a need for prompt action due to an actual or threatened disruption of public facilities. It has to be something that is so severe that it impairs public health, safety, or both. I've never actually seen an emergency meeting called in the time I've been doing this. Not to say they don't happen. Also, and there's no slide on this one, any regular or special meeting can be adjourned to a specific time and place. Then it's referred to as an adjourned regular or special meeting. We did that last week with the strategic plan update. We adjourned to the next day to have to finish up the work. You have to post a notice within 24 hours. If it's within less than 5 days, no additional notices are required. You just have to post it on the door of the place where the meeting took place. Generally, and again, there's no slide on this one. This is more on the topic of where meetings have to occur. And generally, they need to take place within the boundaries of the territory over which the agency has jurisdiction. So in the case of Cambria, the boundaries of the district. There was a flap a few years ago about a meeting that occurred, the South County Sanitary District is holding a closed session to do video interviews by a new general manager. And they held it at the Embassy Suites in San Luis Obispo in a conference room. And they got called on it, and they had to redo the meeting properly and redo the interviews. A friend of mine was their district council at the time, and we had a good laugh over that one, but he kind of blew it. Now, there are several exceptions to comply with the state and federal law and court order, or to attend a judicial or administrative proceeding that the agency is a party in, to inspect real or personal property that can't be brought into the boundaries, but only to the extent that it's limited to things relating to that property. There's an exception for multi-agency meetings that are held in the boundaries of one of the participating agencies, but then there's a notice requirement for all of the entities that are participating. A few other limited ones, meeting in the Office of Legal Counsel for a closed session on pending litigation, or to do so would reduce legal costs or fees and so on. I actually used that in 2004. Simi Valley had a case that went to the U.S. Supreme Court, Mueller versus Maina, the police-related case. And I had three counsel. We had quite a contingent that went to Washington in December of 2004 to observe the oral argument. Again, that falls into another exception that can attend the hearing. We had three council members. We had the two police officers and their wives, our city manager, myself, a couple of attorneys that had handled the case at the trial court and a Ninth Circuit Court of Appeals. And we hired Supreme Court litigator Carter Phillips, who's argued, I think, 80-something cases at the U.S. Supreme Court, more than just about any other attorney in the country. And so we held a closed session at his office the day before the oral argument, so he could go over with the city council the argument and issues and how it was going to play out. And we actually noticed a closed session and posted it under this exception of the Brown Act. And I remember going to a luncheon And I was sitting next to the guy from the DA's office who does their public integrity stuff, Brown Act and conflict of interest and stuff like that. And I was telling him about how we had done that. He was impressed. We had done it right. We won the case 5-4 with one of Rehnquist's last opinions. Mueller versus Maine is the name of the case. Anyway, moving on, we're going to talk about teleconferencing, Zoom meetings that we all got used to during the pandemic. It actually also had an evolution as far as how we got to where we are now. In this slide 13, you can put it up, but it's, we'll talk about that in a moment. But as a result of the pandemic, the governor issued an executive order suspending some requirements of the Brown Act. And everyone was scrambling in terms of how to hold meetings. We started using Zoom and have Zoom meetings that comply with certain things. And subsequently it was followed by AB 361, which added Government Code Section 54953 E, subsection E to the Brown Act. That statute permitted remote meetings in certain limited circumstances. A certain determination had to be made by the legislative body if there was an imminent risk to health and safety to attendees. There used to be a social distancing requirement too, that would be in effect, but that's not in the statute anymore. You had to make this finding initially every 30 days, now it's every 45 days. The statute was amended last year to eliminate at the end of 2023, so effective January 1st of 2024, change that. It can only be used when there is a declared emergency, a state of emergency in the state declared by the governor, not a local emergency. It has to be a statewide emergency declared by the governor under certain statutes that empower him to do so. That's not the case now, of course. That statute is scheduled to sunset in 2023. It was extended, so it's not going away. Yeah, but it's still only available during a declared emergency. So, but when it comes to remote meetings, teleconferencing, we're talking about the attendance of the legislative body at a meeting such as this. Even without using these teleconferencing rules, staff can still participate, consultants. I know district council will participate remotely. I've done that. In any case, you can still use Zoom. The public, of course, can participate by Zoom. That's not a teleconference for purposes of the statutes. Traditional teleconferencing, which is 54953B, that's a law that's been in effect for quite a number of years. And it requires certain things in order to do teleconferencing. You have to post the agenda at the location, as well as identify the locations where a member of the legislative body is participating remotely. The public has to be able to access the location. There's several other requirements, at least a quorum has to participate from locations within the agency's boundaries. Public has to be given a right to the ability to address the legislative body in each of these remote locations. During the wind down of redevelopment, there were what were called oversight boards that were created, and I sat as the legal counsel to Santa Maria's oversight board, and actually Pismo Beaches and Rodriguez. Santa Maria's oversight board had a couple of members that were appointed by the Board of Supervisors and were staff of the Board of Supervisors in Santa Barbara County. And they would always participate remotely using this exception. We would have to follow those rules because they didn't want to have to come up to Santa Maria from Santa Barbara. And so participate from a conference room that was open and accessible to the public and posted and so on, at the county building in Santa Barbara. There was a new law, relatively new law, in, effective in January of 2023. And I added these slides the last time, and I committed the cardinal rule of PowerPoint, not that I know much about PowerPoint, but I did prepare this slide, and that was putting too much information in the slide. But this statute, AB 2449, added an additional and kind of complicated and limited provision to the Brown Act, 54953 subsection F, that allows teleconferencing without having to comply with all of the provisions of the traditional teleconferencing statute, such as the posting of agendas and public access and so on, and including the locations on the agenda. It's complicated, it's very limited, it requires what are called just cause or emergency circumstances as defined by the statute. So just cause could be childcare, caregiving, contagious illness, physical or mental disability, or travel on official public business, or it could be emergency circumstances. A physical or family medical emergency that prevents a person's attendance. To use just cause, a member has to notify the legislative body at the earliest opportunity of the need to participate remotely. And that can only be used twice in a calendar year. The emergency exception, you have to request it as soon as possible, and the legislative body has to take action to approve it. And it's actually one of the exceptions that was added to the statutes on action that's not on an agenda that can be taken by a legislative body approving board members' participation using the emergency circumstances. The statute also previously had a fairly complicated section regarding how many times it could be used. That was amended effective January 1st of this year. Now it can be used to, in addition to the 2 times on the just cause. 2 times if a body regularly meets once a month, 5 times a year if it regularly meets twice a month, and 7 times a year if it meets 3 or more times regularly. Again, regular meetings presumably is what regular means. This statute is set to sunset on January 1st of 2026. However, there's a bill that's actually being sponsored by CSDA, California Special Districts Association, that was a new bill that's pending as of January that would extend it and eliminate the sunset clause. I haven't seen this statute used. I think it's kind of complicated and tedious. If there are specific circumstances that apply to anybody, contact district council and we'll figure out how to actually implement it and make sure we do it properly. Finally, this last year, just on these remote meetings, the Attorney General's office issued an opinion concluding that allowing a member of a legislative body to participate remotely could be a reasonable accommodation for a qualifying disability under the ADA, the Americans with Disability Act. It was kind of interesting because this reversed a position they had taken in a prior Attorney General's opinion, and they based it on these subsequent amendments to the Brown Act on remote meetings, saying that provisions and circumstances that related to their prior opinion no longer applied. So I thought that was kind of interesting, and it ended up in one of my sticky notes as a change since the 2023 presentation. Okay, let's go to 16, I guess. Where am I? 15 had more on AB 2449. Yeah. And like I said, it's Yeah, well, a number of specific requirements and as a book is to deal with. Let's talk about agenda contents, 54954.2 and posting. The Brown Act requires agendas for regular meetings to be posted 72 hours before the meeting. It also is required to contain a brief general description of the business to be transacted. The statute actually defines brief general description as something that generally doesn't need to exceed 20 words. The idea is basically to put the public on notice of what business is to be transacted so that they can make an intelligent decision as to whether or not they're going to observe the meeting, participate, come down to the board meeting and so on. There was a case a couple of years ago where the court held that not including language on the agenda, that the agency was going to make a finding of exemption from CEQA, violated this requirement regarding the agenda description, which set off a bit of a stir. That case was depublished. There was a Court of Appeals case. There was a petition to see if the California State Supreme Court would take it up. They declined to do so, but they took the action of quote depublishing it, which means it was no longer citable as case law. So they kind of took a backdoor approach to doing away with that decision. But the courts seem to be getting stricter when it comes to agenda descriptions. And I know Tim Carmelo's gotten real strict with staff as far as agenda descriptions to make sure that they read correctly and put folks on notice. Agendas have to have the date of the meeting, time, location. I have to have how to request a disability related accommodation. So those are some of the requirements for agendas. Let's see, it's on slide 17, so we kind of covered that. If you want to put that up, I understand that the PowerPoint has been made available to folks, so I'm going too quickly. In 2019, there were also provisions that I'm not going to go over in detail with regard to posting requirements on websites, the formats. Most agencies are already doing that in some way. It has to be accessible through a prominent link, things like that. And of course, that's something that Haley made sure that we're complying with. So let's go to slide 18. Special meetings. Special meetings only have a 24-hour notice requirement. And they can be called by we talked about this a little bit already, the presiding officer or majority of the body, but not by staff. You're required to allow public comment on the agendized items, but not on non-agendized items. Regular meetings, as we'll talk about in a moment, have to have an opportunity for folks to talk about things that aren't on the agenda. Special meetings do not. Public comment is limited to those items that are on the agenda. Slide 19. Okay. So now we're on the public's right to attend and observe and participate. Members of the public can't be required to register their names or provide other information as a condition of attending a meeting. You can have attendance lists, but it has to state on it that signing in is voluntary. Public has a right to review agenda materials. They're not privileged documents like attorney-client privilege and things like that. Documents that are make up the agenda of public records. If written documents are distributed to a majority of a board, they have to be made available to the public. As far as things that are not on the agenda, The Brown Act has limits. You can't act or discuss items not posted on the agenda. So let's go to slide 20. Members can, or staff, can briefly respond to comments or questions from members of the public. Now, this can be frustrating to people who attend the meeting, they have some issue. And there's lots of folks that don't really pay much attention to the board here, other than when they have a problem, or a city council, or a city business. And then they come down to the meeting and they have a problem, and they get up during a public comment and talk about their problem. And are maybe a little frustrated that the body can't solve their problem on the spot, can't really discuss it. They can refer it to staff, they can briefly respond. But it's not something that can be taken up and dealt with necessarily. There are exceptions, even without comment from the public. A board member can request information, ask for a report back, request to place a matter on an agenda for a subsequent meeting within the rules of the body. Ask for clarification, make a brief announcement, briefly report on their activities. A lot of agendas will have board member or council member reports. We had that in Simi Valley, and have to be careful because, you know, the council member would make a report. I had this happen all the time in Simi Valley. And then you had to be careful about getting the rest of the city council drawn into a discussion. I had one council member that would look around after making his report and say, I'd like to maybe get a sense of the reactions of the rest of the council of this. And I would lean forward. We had this little game the city manager and I would play. And I would lean forward and the city manager would say, David is getting nervous. And that would usually cut off the rest of the discussion. There's also an exception. The main one that comes up is when something comes to the attention of the body after the agenda has been posted, and there's a need for immediate action. And there needs to be a 2/3 vote, or if less than 2/3 are present of the body, then all of the members have to determine that there's a need for immediate action, and that it came to the attention of the body subsequent to the posting. So it's kind of specific. I've seen it used a number of times. It'll come up, for example, where you have a deadline to apply for a grant and you didn't know about it, staff didn't know about it, suddenly they get information about it after the agenda is posted and you're gonna miss out. Circumstances like that, again, there's certain determinations that have to be made in order to utilize it. So let's see. So the exceptions were in slide 22. In slide 21 rather, I'm sorry. Slide 22 is the public's right to comment. The Brown Act provides that for regular meetings, and again, not for special meetings, agendas have to allow members of the public to speak on any item of interest within the subject matter jurisdiction of the legislative body. Often it's called public comment or citizen input on agendas of public agencies. They have also a right to speak on items on the agenda before or during the board's consideration of the item. So in a sense, everything becomes a public hearing. You know, we hear about things that quote public hearings, and there's a category of things on agendas for the board here and otherwise agencies have public hearings. Public hearings are typically things that are required by statute to have a public hearing and usually have a specific noticing requirement as well. Publication in the paper, a certain number of days, it's all statutory. But everything is a public hearing to the extent that the public has a right to comment on everything that's on the agenda. And things that aren't on the agenda that get up and speak to things within the subject matter jurisdiction. The law says that you can have reasonable regulations, including time limits. 3 minutes is typical. The Royal Grande just recently went to 1 minute. I don't know if anyone's challenging it. That seems a little dicey to me. There's case law holding 3 minutes. And so you have 3 minutes is what we do. You know, board members and legal counsel and all the staff, and we listen to public comment.
Sure.
It's open process.
Well, if we don't like 3 minutes,
Well,
oh, it should be 5 minutes.
that will be up to the legislative body to set that time limit. And
Can
if,
we order somebody else to state
excuse me,
in a local meeting, the CCSD, they have typically 3 minutes.
the CCSD board has the ability to create a time limit.
That's good, but I'm suggesting is what if we didn't like that? Who can go against that?
There's,
Thought,
there's nobody that can go against that.
even the public, it says they want something different.
There's no,
Sounds like it's
I
not
am not
written.
aware of any mechanism that allows the public to set the time limit. In fact, you can have a time limit on how much time you devote to an agenda item. That's also in the Brown Act.
We never do that, we go overtime.
I understand. I don't know of any agencies that do that. I've seen it come up in one of my cities when I was city attorney, where we had items that were gonna take up a huge amount of time, we're gonna go past midnight. But we chose not to do it, but there was a discussion about doing that. But in any case, the board has the ability to have a reasonable time limit. 3 minutes is used. I wouldn't say universally, but all over the state. The agencies that I'm familiar with use 3 minutes.
Like my question, theoretically, we don't have to use 3 minutes.
They don't have to, it's up to the board.
So we have to elect a new board if you want to change that. I don't know, it's you're just saying nobody can do it.
I understand,
Public
your
can do it. if
I,
you-
I understand your point, but it's a discretionary call made by the board. And a 3 minute time limit has been upheld by the courts. So I'm not sure how useful this discussion is getting.
No,
I
it's
understand
fine.
your point,
Yeah.
but, no, the public doesn't have the ability to change it.
No, not very good at.
Can I ask a question? Sure.
Not really relative to that. When people come to the meeting, they don't have to sign in or anything like that.
We don't have that requirement.
No, nor can you, apparently.
Right.
However, when people get up, when there's a public comment, usually the president of the board will ask the person to their name and where they live or what town they live in or something like that. So if they want to speak, then they have to identify.
If they want to remain not anonymous, they can speak anonymously.
Okay, they don't have to,
There's a right to anonymous speech.
even when you send up.
Yeah.
Okay, all right.
Regarding what happened in Royal Grande when they limited public comment to 1 minute, what justification did we get for that?
I can't really speak to that.
How was the public responding as a result?
The public, there are folks who I know who have spoken at meetings that don't like it. That's after, Tim is no longer city attorney then. And I was the assistant city attorney there for 14 years, part-time basis as I am here. But, I don't know what the rationale was. I know that there are folks there that are not happy with it, that have gotten up at meetings and spoken against it. And that's about the extent I can. So, the law specifically also, let's go to 23 and disturbances. Let's see, the law specifically says that you can't prohibit public criticism of policies, procedures, programs, or services of the agency or the acts or omissions of the board. So people have a right to get up and criticize. There are specific provisions, as we know, board meetings, council meetings, can sometimes get a little testy. I've attended many meetings where One half of the group is in favor of, the audience is in favor of something, the other half is against it. We've had some pretty exciting meetings here in Cambria. I remember in 2014, Prop 218 hearing we had relating to the building of what we now call the WRF. So, someone set off a stink bomb during the middle of that meeting. For any of you that were in attendance. So the Brown Act does contain some provisions relating to disturbances of meetings. One of which is relatively new. It was adopted in 2022, adding 54957.95 to the Brown Act. And it set out some procedures where the presiding member of the body, president, this for the board, can have an individual removed who's disrupting the meeting. And there's a process. You have to warn of the disrupting behavior. If it doesn't cease, as a result, that person can be removed and so on. Disruptive behavior is defined as behavior, excuse me, that disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting. There's another section in the Brown Act that's been there for a long time, 54957.9, that speaks more in terms of disruptions by a group. And it allows for the clearing of the room and continuing the session without people other than the press can be let back in. I've never actually seen that used. In some agencies, we have prepared scripts for board presidents or mayors to use where they were concerned. I had a mayor that was a former police chief. In fact, I've had 3 mayors in my life, former police chiefs, that was concerned about a disruption at a meeting because of the subject matter. And we sometimes in Simi Valley, we'd have police in the room. They work with the city. Sometimes we have plainclothes police, sometimes uniform. The script usually would be something not too dissimilar from what 54957.95 says in terms of trying to bring order back, take a break, try to get tensions cooled down. There's also a section of the penal code 5483 that makes disrupting a public meeting unlawful. And that statute has to be carefully used. The penal code section could result in someone being arrested for a misdemeanor. They're disrupting the meeting, but obviously it also bumps up against First Amendment issues and the rights that people have to speak. So you need to have conduct that is truly disruptive. There's some case law on it. It's typically a criminal case where someone is fighting their conviction of having violated penal code section 403. I know there's one case where someone came to a meeting upset in the city, upset about trash in their neighborhood, brought several trash bags full of garbage, and then proceeded to go up to the podium and dump all the trash. And then they got arrested for violating penal code section 403. But again, you have to be mindful of the First Amendment issues associated with folks participating at a public meeting. So, yes.
May I request, a member of the audience has insightfully requested a break. So we're a little past halfway. I recognize
Sure.
that we have Q&A. Could we?
Yeah,
perhaps
that's fine. Let's take a break.
break it? And with a group of in excess of 20, 5 minutes wouldn't be sufficient. Maybe a 10-minute break.
That's fine. Okay. I somehow inherited this, PowerPoint, and I realized that slide 24 is something that we've already covered, so, we'll move on from that one. And talk about closed sessions. Okay, let me know when you're ready.
Yep, you're good.
Okay. And I wanted to, touch on closed sessions because it is the major exception in the Brown Act to doing things publicly. But it's not likely that the standing committees are going to be holding closed sessions. The board, of course, has occasion to hold closed sessions, but not the standing committees. But still, it's important, and it reflects the fact that there are tensions in the law when it comes to this notion of open meetings. Everything can't be done publicly. And there are some legitimate reasons and needs for closed sessions, confidential meetings. But there are limits, and those limits are strict. They, in order to hold a closed session, it has to be based upon one of the statutorily authorized closed session exceptions. Just because something is sensitive, embarrassing, controversial, doesn't permit it to be discussed behind closed doors unless it's within one of the authorized closed session exceptions. Also, it's important to point out that the confidential information that's acquired in a closed session is not supposed to be disclosed unless authorized by the legislative body. There's some remedies in the statute about leaks from closed sessions, and those kind of issues can be difficult to deal with. The remedies are not very good or useful. I've encountered a number of occasions where information was being disclosed, and I had city councils where four of the council members are absolutely certain who's leaking that information. What can we do about it? Those can be often difficult to deal with. Authorized closed sessions, there are several types. Go to slide 26. There are a number of personnel related closed sessions to appoint someone, to evaluate performance of someone appointed by the legislative body, to discipline or dismiss someone, to hear complaints against the agency's employees and an employee. There's also an interesting provision where there's a complaint against an employee, and that's the subject of the closed session, where the employee has to be given the right with 24 hours notice to have those charges heard publicly. Never seen that happen, but that's another T to cross, I to cross. I've seen that utilized in terms of contacting the employee and documenting the fact that you gave them that right. Pending litigation, next slide, 27. Whoa. And this is where the Brown Act allows meeting with legal counsel to discuss pending litigation, where to discuss things openly with prejudice, the agency's position in the litigation. The statute is very specific as far as what constitutes pending litigation for purposes of the act, including circumstances where the body is deciding whether to initiate its own litigation. Could be a pending case in front of a court or administrative body. It could be an administrative hearing officer kind of situation. Significant exposure to litigation. The law is very specific in defining what constitutes significant exposure to litigation. In some circumstances, specific facts and circumstances that support the fact that there is a significant exposure to litigation has to be disclosed publicly. The law is very specific, and Tim and I make sure that it's always adhered to and go in on a closed session. You can have real property, closed session, slide 28. And, the board, can need to discuss the price in terms of payment in connection with the purchase, sale, lease, or exchange of property by the agency. You have to, identify the property in question and who, is acting as, the agency's negotiator and who the negotiator is authorized to negotiate with. At the conclusion of a closed session, you have to report approval of any agreement. With a final agreement, we'll talk a little bit about announcements and so on too. Labor negotiations, slide 29. Board can meet in closed session to have discussions with both employee organizations, represented employees. Here we have two. We have the SCIU and we have the firefighters unions and unrepresented employees as well. Yeah, regarding basically the closed session is to instruct its negotiators regarding discussions, negotiations with represented and unrepresented employees regarding salaries and fringe benefits. And when it comes to unions, other matters within the scope of representation as defined by the statutes that govern employee-employer relations in California, the Myers and Elias Brown Act, it's called 3200, I think it is, that's secretary of the government code. Employee is specifically defined, does not include elected officials. It can include a independent contractor who functions as an officer employee, such as the district council. But otherwise, it does not include appointed or elected officials, such as board members or members of the standing committee. Go to slide 30. We skip over it. Anyway, 30, there is also the ability to have a closed session with the Attorney General, the District Attorney, District Council, Sheriff, Police Chief, on matters relating to threats to security of public buildings, services. We did that in Simi Valley because of 9/11. We had a closed session to meet with the police chief to talk about the concerns relating to security of city facilities. As of January 1st of this year, there's a new amendment to the statute that allows closed sessions on threats to critical infrastructure control or critical infrastructure information because of things like ransomware. That amendment is effective on January 1st of this year. There's an additional one relating to license applications where there's a criminal record involved. I've never seen that used. But it is in the statutes. There are, as far as violations, and we're getting near the end here. Violations of the Brown Act can be both either criminal or civil. Civil remedies allow either the district attorney or any interested person to bring an action to get a judicial determination that an action violated the Brown Act and could be rendered null and void. However, there are procedures that have to be followed that are laid out in the Brown Act. There has to be a written demand to cure and correct. There's another cease and desist process to stop future violations, or demand has to be made. And the statute lays out the process rather specifically. It also allows for the recovery of costs and attorney's fees if someone brings an action like that and then prevails in the action. So it can be costly. Court could also invalidate an action taken in violation of the Brown Act. I remember in 2021, we had the district attorney contacted us here in Cambria about arguably a closed session violation. And we felt that we were correct in how we handled it, we communicated our position to the DA, and they withdrew their concerns. There's also criminal penalty provision. It's a misdemeanor to attend a meeting for a member of a legislative body. To attend a meeting where action is taken in violation of the Brown Act, where the member intends to deprive the public of information to which the member knows or has reason to know the public is entitled. It's a specific intent law. In criminal law, there's specific intent laws. And that's what that is. I've never heard of it being utilized. I have read that the media, which again is often the watchdog of and protector of the Brown Act, has grumbled that there's really no effective provision, criminal provision, because it's really never been used. But it is there. The proper set of circumstances, I'm sure it would be used. And keep in mind the district attorney's office here in San Luis Obispo County, as they have in other counties, has their public integrity unit. They have an attorney who is assigned Brown Act issues, conflict of interest issues, and so on. Just a few miscellaneous things, and we'll have to wrap it up. The act applies to newly elected officials who have not yet taken office. So after the election, someone has won, they haven't been seated yet. That person has to conform their conduct to the Brown Act. They can't get together with two sitting board members and start discussing the business of the body, because that would be a Brown Act violation. Members of a legislative body cannot act by secret ballot. So no filling out a slip and passing it up to the chair. As far as voting, you have to, state things publicly, and votes have to be recorded publicly and so on under the Brown Act. Public also has a right under the Brown Act to make audio or video recordings, unless doing so it can be found to somehow disrupt the proceedings. And of course, we know people just hold their phone up now and make a recording of the meeting. Also, recordings of meetings are public records. And so they can be destroyed actually after 30 days. But the recordings are public records. They typically are kept much longer than that by agencies. And that's pretty much my presentation. So if there are any other questions, I'd be happy to give it a shot. Otherwise, thank you for your attention. Yes.
Unless I missed something, maybe you could speak a little bit to, I guess, guiding principles or whatever relative to the Brown Act with ad hoc committees.
Well, ad
Does
hoc,
that make sense?
yeah, ad hoc committees, again, consisting solely of less than a quorum of the legislative bodies, are not subject to the requirements of the Brown Act as far as notices, agendas, and being public, the meetings being public. It's an exception to the Brown Act.
Okay, so just so I clarify, so let's say you're a member of standing committee and in an ad hoc committee, that you then could communicate as a member of that ad hoc committee to anybody?
No, the meetings of the ad hoc committee are not subject to the Brown Act. You still cannot have communications with other board members of the legislative body, because then you're getting into the Brown Act violation. But you can, but the meetings of the two members of a 5-member legislative body that have been appointed to an ad hoc committee, again, specific task, goes out of not continuing subject matter jurisdiction, but the task, once it's completed, the ad hoc committee goes out of existence. Their meetings are not subject to the noticing requirements and don't have to be made public, things like that. But you can still have a Brown Act violation if those two members then start talking to a third member.
As a member, one last question related to that, as a member of an ad hoc committee, in communicating, not in violation of the Brown Act, is it acceptable for a member of that ad hoc committee to communicate directly with another member of the legislative body, let's say the board of directors?
No, a different legislative body?
Well, so let's say somebody at the board of directors.
That's a different legislative body.
I'm sorry?
That's a different legislative body for purposes of
Okay.
Brown. But otherwise, if an ad hoc committee wants to report to the rest of the legislative body, you agendize it. You put it on the agenda. Yes.
I just have a follow-up on his question. So as being on an ad hoc committee, it's one, the lady and I that are on this committee. So the only people that we can't talk to are the 3 other members of the finance committee. Everybody else in this room, except for them, we can talk. Okay, it's just not those 3 other people. Okay, I just wanted to be sure.
Yeah, but they are not members. You can't have someone who is not a member of the legislative body on the ad hoc committee, so you can't have,
They're not.
you can't have the chair of the committee, the finance committee, appoint some other person to the ad hoc committee.
That's,
They cannot be a member.
now that raises another question. So does the chair become a 3rd person if the 2 of us were to talk to?
We've changed the bylaws so that the chair now is a non-voting member of the standing committees.
Okay.
And doesn't count toward a quorum.
Okay, so that.
It was a
that
little
exempts them.
confusing when we had a 6-member body, and it raised some concerns regarding how some of these things functioned. But that more recently has been cleaned up. And so the chair of the standing committee is a non-voting member who does not count toward the quorum.
I believe we also changed the bylaws to state that the chair of the standing committee cannot be a member of the ad hoc committee.
Just for perceptions and things like that.
On that topic, could you speak briefly on, I was looking at the wording, but there's some wording on the chair providing direction to the ad hoc committee and how that interface works.
I think the chair, when creating the ad hoc committee, sets out the task the ad hoc committee is performing.
But then once the ad hoc committee is formed, the chair cannot communicate with both members of the ad hoc committee outside of the standing
Yeah,
committee.
I think we concluded that
Yeah.
for appearance purposes, if nothing else, that given that structure of having a non-voting chair, which is, to be honest, it's pretty unusual. Just as it was unusual in my view, when we had a 6-person body, but the chair only voted if there was a tie. I had never seen that before either. So, yes.
Maybe, Dr. Dean, on real quick, you've got bylaws, the added bylaws say, basically barring the chair of the committee, anything from communicating to the 2 members of the ad hoc committee, just basically for the appearances, because you're right, it's legal, it's illegal, but it doesn't look like, you may not look that good. But one question I want to make sure we're clear on this about what ad hoc committee can do in way of meeting with people. My understanding is with ad hoc committees, any ad hoc committee, they can talk to anybody, the public, they can have a larger group of people actually in public and working with them. We've done that before, in their meetings. They're not public meetings. There's not to be noticed, they're not Brown Act compliant, or you have to have members of the public invited to control with them.
Sure. The ad hoc committee is acquiring information to perform their task and they'll ultimately report back with recommendations to the legislative body.
Thank you.
Are there any meaningful distinctions between communications that can occur between members of a standing committee and that of a legislative body? Because the standing committee does not make decisions, does not make legislative decisions. Are there any distinctions in the prohibitions?
Not really, but certainly standing committees are making recommendations and transmitting those recommendations to the legislative body. Bear in mind, there's some committees or commissions of public agencies that do have more substantive authority when it comes to decision making. But that's, you know, like a planning commission, for example, for a city or county. But for the most part, the standing committees here are making recommendations to the board and are functioning as an advisory body, but they're still subject to the Brown Act, even though they're an advisory body. Thank you.
From the closed sessions, directly after the meeting, there's supposed to be a report given of what transpired.
Yeah, I should have talked about that. Let me talk about that a little bit. There are two things. One, there's a provision in the Brown Act that specifies how closed sessions are to be identified on the agenda. And if you conform to the format of that statute, then you're in substantial compliance with the Brown Act. It's called the safe harbor agenda descriptions. The other thing is reports out of closed session. I should have touched upon that. I think it's in my notes. I just skipped over it. And that is, there are specific circumstances that govern what needs to be disclosed after a closed session. And to be honest, they're fairly narrow. Only very specific certain things have to be disclosed. If the board is meeting in closed session to give instructions to its negotiators, with one of the unions, for example, that does not need to be disclosed. Just as a matter of transparency, we might end up saying, we held a closed session, we gave instructions to negotiators with SEIU or whatever, but that's not even required to do that. It's very specific. It's usually when a final decision has been made on something. So, again, it has to be a final decision. So for example, if there's pending litigation and the board is signing off on a settlement and their decision is the last element of that settlement of this litigation, the other side having agreed to it and signed it, that has to be recorded. However, if it's not final yet, still needs to be signed by the other side, or just gave authority to settle in some dollar amount with the person that brought the lawsuit, that does not need to be disclosed after the closed session. It only becomes public, and this is in the statute, after it's final, and then it's subject to disclosure upon equal. So the statute is very specific and narrow as far as what has to be disclosed after a closed session. And I think that confuses people because often after a closed session, there's nothing substantively being disclosed, but that's because of the way the law is structured.
So how much is disclosed is up to the person in their meeting. The answer I'm avoiding here is it says nothing was discussed or nothing was voted on or whatever. And that's all they say. That's nothing to even know what's going on at all and who's doing what or whatever, any other private details.
Well, but keep in mind that the reason for holding these closed sessions is because of a recognition in the law that there are some things that you need to do behind closed doors. And if you're negotiating with SEIU and giving instructions to your negotiators, you don't want to have to disclose what that negotiating posture is. You want to be able to give your negotiator an opportunity then to go and negotiate. If you have a lawsuit and you're having a closed session to talk about the agency's position in the lawsuit, you're not going to run out and start publicizing the facts and circumstances that might prejudice the lawsuit. The law recognizes that there are certain things that can't be done publicly. And then it does have carve-outs and specifics regarding what and when certain things need to be disclosed. And it's all statutory.
So a lawyer knows that is what you're suggesting. Because the public doesn't know anything.
Well, certainly,
So we're sort
district
of out
council,
here saying, oh, what's going on?
district council needs to be cognizant of what needs to be disclosed and provide for proper disclosures when it's appropriate.
That's my question. I don't think sometimes that happens. Most of the time they say nothing was settled and we sit there, nothing is known anyway, so what you're doing for 2 hours.
Well, we try to do the best we
No,
can.
that's fine. So I'm suggesting it needs to be a little more open to things that can be disclosed as opposed to things that stands on to be the heroes and say, okay, nothing was voted on.
I understand the concern.
It's something we need to look at.
Yes.
Yeah, I just have a question. If I understood correctly, seem to be saying that the committee has to stick pretty closely or has to stick to the agenda items that are distributed to the public. What about a scenario where part of what you're doing is brainstorming? I mean, how do you ensure that you have a free flow of ideas and free conversation while also sticking to close up to the agenda? Do you just establish an agenda item more broadly that can encompass some of that kind of more speculative conversation?
I think that really revolves around how the agenda item is framed. Again, the public has a right to be there, to know what subject is, make an informed decision as to whether they want to be there or not. So the agenda description needs to be descriptive in that sense and inform what the subject matter is that is going to be discussed, even if it's just a brainstorming thing.
How many violations of the Brown Act are done every year? How many have been reported or processed?
I don't know how to answer a question like that. We're a big state with lots of
Well,
public.
you mentioned several ones that they thought they were going to do something, but my understanding is that there's probably been any violations of the Brown Act reported or prosecuted.
Criminal
People can't
prosecution,
see that good.
well, criminal prosecutions, no, I'm not aware of any. Other circumstances where an individual or the district attorney has contacted an agency and required them to change their behavior in some respects. You see articles about that in the paper all the time. And how many? I couldn't tell you.
Just wondering, it doesn't seem to be a large number.
So if there isn't anything else, again, thank you for your attention and hopefully that was
More
helpful.
questions?
Oh, no, thank you.
On behalf of the president, at this part, but we do that in advance. Just a sincere thank you to Mr. Hirsch. Fabulous, clear explanation, presentation, great engagement of the group. Thank you for that. It's 11:50 a.m. and this special meeting is adjourned.